Hello, hello, hello again, everybody. Paul Rabelais here, estate planning attorney, giving you another live stream. Don't like to waste time, like to jump right in. So, title of this one, the $18,000 present interest to annual exclusion. Had a good question already in advance. Of course, hello, Larry. Larry's on with us most of the time, so always great to have Larry. Had a question there from 3B Productions. Let me go ahead and address it because maybe my title, not maybe, but my title can be confusing to some people the way I wrote it. So I wrote the title as the $18,000 present interest annual exclusion. I think some people, when they see that word interest in there, they're thinking about, who pays the tax on interest, like interest from a savings account or interest from a certificate of deposit. And the word present interest annual exclusion has nothing to do with that. When it says interest there or present interest, and we're going to talk about this in the live stream here, but really present interest as opposed to a future interest. Don't worry if you don't get it. You'll get it in a few minutes. It's one of the key points that I want to make, particularly when we start talking about parents and grandparents, for example, making gifts in a trust for a child or a grandchild, a niece, a nephew, or quite frankly, anyone else. So good question there. We're going to get to it. So I'm breaking this live stream down into 4 parts. Just one is, what is the $18,000 present interest annual exclusion? Number 2, what are some of the exceptions to taxable gifts? Again, you'll understand this when I get into it. I want to describe all of this stuff in layman's terms, but I want to break it down into the 3rd part, where I do want to address unique rules that apply when gifts are made to trusts for the benefit of another. And then the 4th part of this live stream is just a bunch of unique special considerations that we're going to be hitting kind of all over the place that just didn't fit in one of the first 3 categories. All right. Good to see you, Amy Smith. You have a phenomenal first name, the same first name as my wife. So great that you like the channel. Okay, let's jump in. First thing I want to go over is, what is the $18,000 present interest annual exclusion? All right. Once you really understand it, you're going to realize that this $18,000 present interest annual exclusion can affect many people, although really the full effect is it doesn't affect many people at all. People love to comply with this $18,000 rule, as I'll call it, even though there's really no financial penalty for failing to comply and you'll understand failing to comply with it, and you'll understand all of that as we go along. But many of these, I got to warn you, many of these strategies that I'm going to talk about work well, but you have to be able to kind of financially swing it to take advantage of it. So while comments to my YouTube videos and comments on the live chat have been 99%, positive, occasionally you get the kind of wingnut and I have to exclude them from the channel. It's only happened twice, I think, in all the videos and all the live streams that I've done. But we do have a rule that we want to keep all the live chat, the comments, the experiences, the questions that you have, keep that positive. So got one kind of wonky comment a while back. They were like mad at me because some of the strategies that I discussed really only applied to people with some wealth. And so, I'm just the messenger. So keep it positive, and thanks for all that in advance. All right. Another reason I like the fact that we're doing this live stream here in February of 2024 is that some of you may discover that you did something in 2023 and you have a reporting requirement based on something that you did in 2023, and the reporting requirement deadline is April 15th, 2024. So here we are in February 2024. If something you discover makes you think, oh boy, I've got to do something now, I don't realize it, you've got almost a couple of months to get it done. And I realize we'll talk about the gift tax filing requirement just happens to be the same date as the income tax filing requirement. More on that later. All right, so the present interest annual exclusion amount is is the amount at its most basic level, is the amount of money or assets, it doesn't have to be money, that you can give to another person each year without incurring any gift tax consequences. And we'll have to define what gift tax consequences means, or without affecting your exclusion amount. So let me just give you the most basic of examples. Let's say dad writes a check to his daughter for $18,000, and $18,000 is the present interest annual exclusion amount for gifts that are made during the calendar year 2024. The year before this, 2023, it was $17,000. And you know what? I think the year before that, 2022, it was $16,000. So it's gone up, by $1,000 each of the last 2 years. It typically doesn't do that, but the inflation numbers were high. It goes up. It's adjusted for inflation every year, but it only goes up in $1,000 increments. So if the inflation adjustment doesn't cause that number to go up by $1,000, it just doesn't go up for the year, and perhaps it'll go up the following year. So anyway, when I first started working as an estate planning lawyer back in the early to mid 90s, the present interest annual exclusion was $10,000, and it's gradually gone up over time. In fact, people still ask me, Paul, isn't there that thing where you can give $10,000 to as many people as you want to? And I'm like, yeah, you heard that 20 something years ago, but it's not $10,000 anymore. It's $18,000. And next year, maybe it'll be $19,000, maybe it'll be $18,000. We just won't know until the end of this year what it'll be next year. So real simple example. Dad says, you know what, I want to help out my daughter. I'm going to write her a check for $18,000. So, and dad could have any number of motivations for writing his daughter a check for $18,000. Maybe she's in a bind. Maybe he wants to help her pay off some debt. Maybe she wants to start a business. Maybe he wants to get $18,000 out of his estate, because if he left it in his estate, it potentially could be subject to a 40% federal estate tax. So these gifting programs, that's the whole purpose behind the gifting programs, is to remove assets from the estate that potentially could be subject to a 40% tax, federal estate tax, when the donor dies. All right, so dad gives daughter, writes her a check for $18,000. What has he done? Well, let's talk about the estate tax consequences. He gets $18,000 out of his estate. Now, that might matter or it might not matter depending upon how wealthy dad is. So if dad has an estate that exceeds $13.61 million in value, that's the federal gift and estate tax exemption for people who die in 2024, then that $18,000 he removed from his estate is going to save a significant amount of tax. If dad has a $2 million estate and he transfers $18,000 to his daughter, he probably didn't need to do that to try to avoid tax, because maybe dad, when he dies, his estate nonetheless would not be subject to estate tax anyway. We've talked on other live streams about how the estate tax exemption is $13.61 million. Next year, it'll be even higher because it'll go up, again, adjusted for inflation, maybe around $14 million. Who knows? That's just a wild guess. And then in 2026, it's going to be adjusted for inflation again, but cut in half. So it might be around $7.5 million in 2026 for people who die in 2026 and beyond. So next, let me give you an example of the previous example. Dad wrote a check to his daughter for $18,000. He got that $18,000 out of his estate, and he didn't use any of his estate tax exclusion amount, because generally speaking, the federal government says, hey, yes, if you make gifts to other people, you start using up some of your estate tax exemption during your lifetime by making gifts. But the first $18,000 that you give to someone in a calendar year is not, you're not using any of your estate tax exclusion amount. So Dad gave $18,000. He still has this $13.61 million exclusion amount. From an income tax standpoint, nobody pays income tax on that gift. Certainly the daughter doesn't pay income tax. A gift is not taxable income to the donee or the recipient of the gift. Dad can't deduct that $18,000 gift in any way from his personal income. So these are completely separate things. We have the gift and estate tax on one side, and we have the income tax on another, and they're really not related. All right, so let's expand that a little bit. And now we can start seeing some of the effect of making these gifts. And again, maybe you're thinking, okay, this might apply. Maybe you should be thinking that, maybe you're out there and you're 60 years old. You have an estate, you add it all up and it's $4 million. You're like, geez, why am I even listening to this guy? I can leave $13.61 million and there won't be any gift or estate tax. I only have a $4 million estate. Well, let's go do something else. Let's not worry about this $18,000 present interest annual exclusion. Well, if you're 60 and you're sitting on a $4 million estate, I bet, 10 years ago, I'm just guessing here, it was probably a $2 million estate. And 10 years before that, it was probably a $1 million estate. So that past performance, the old past performance is not indicative of future results. But, you could speculate that you're 60 years old, you have a $4 million estate. If you hang around until you're 70, maybe it'll be $6 or $7 million. If you hang around until you're 80, maybe it'll be $9 or $10 million. And we already know the estate tax exclusion amount is coming back in 2026 to somewhere around $7.5 million. So even though being subject to estate tax is outside the realm of possibility, if you were to pass away today, some of the people that really benefit are the people who do this long range planning, because you can only give away $18,000 to as many people as you want to. And some people get stuck. Their estate is too large. They can't give it away fast enough because they wait too long. So let's keep looking at this. Let's say dad may be thinking, geez, $18,000. What's the big deal about $18,000? I have a $5 million estate. I have a $10 million estate. $18,000 is just a little bit. But when you start expanding that, so for example, let's say dad has 3 children and every year he gives $18,000 to each child. Now every year he's getting $54,000 out of his estate. And let's say he does it every year. And let's say after he makes each gift, then the children invest that money and it continues to grow and compound and appreciate in value. So not only are the gifts out of dad's estate, but the future appreciation on those invested assets that are invested after the gift is made, that also escapes estate tax as well. If dad would have kept that money in his estate, it would have kept growing, more and more estate tax because of the compounding. So let's expand it a little bit more. Let's say dad and mom now are together, and we know now that each parent or each person, dad and mom, can each give $18,000 to as many people as they want to every year. So let's say dad and mom have 3 children. They can give $36,000 to each child each year. So $36,000 times 3, I think that's $108,000 that they can get out of their estate every year. Now we're starting to see how much the tax savings can result. They do that over a 10-year period, over a 20-year period. And that $108,000, once it's transferred to the children and it gets invested and grows, you could wind up with millions of dollars outside of the estate that would never be subject to the 40% estate tax. Expand it a little further. Let's say dad and mom have 3 children and 7 grandchildren. That's 10 people that dad and mom would like to benefit. So now we're talking about getting $360,000 out of dad and mom's estate every year. That gets invested. That gets done every year. That starts to compound. And so now we're, and then let's say dad and mom say, you know what, boy, we really like the amount of assets that we're keeping in the family. We really kind of dig avoiding this future 40% estate tax. And dad and mom say, yeah, our 3 children, our 7 grandchildren, they're all married. Let's give to their spouses as well. So now dad and mom could remove $720,000 annually from their estate solely as a result of the $18,000 present interest annual exclusion. So It can turn into some big numbers. Yes, you do have to financially be able to swing it. So, maybe it's a goal. I've always wondered if I was this Uber several hundred millionaire, what my gifting program would look like. But I'm not there. So, not doing any gifting programs at the moment. I'm 58 years old. I've got 5 kids. I could, if I wanted to, get a lot out of the estate if I wanted to. So anyway, maybe in the future, who knows? So anyway, that's the basics of the first part, $18,000 present interest annual exclusion. I'll give one more example to really show you how the gift and estate tax are unified. Let's go back to our very first example and change it just a little bit. Let's say the first example was dad wrote a check to $18,000 to his daughter. Daughter doesn't count it as income. Dad doesn't get a deduction. There's no reporting required to the IRS because kind of the first $18,000, as I say, is just off the books. You can do it to as many people as you want to every year. But let's change it up a little bit. Let's say dad says, you know what? I want my daughter to buy a house, or my daughter wants to buy a house. I'd like to help her. Houses these days are costing a significant amount. My daughter would like to buy just a normal $500,000 house. And so I want to help her, dad says. Dad says, I'm going to give my daughter $118,000. And so dad realizes, okay, if I give my daughter $118,000, that's $100,000 more than the $18,000 present interest annual exclusion. What's going to happen? A lot of people mistakenly believe that if you give more than $18,000 to somebody in a year, somebody's going to owe some tax to the IRS. And that isn't necessarily true. What happens is by dad giving $118,000 to his daughter in a calendar year for whatever the purpose is, I just made up a purpose that his daughter wanted to buy a house and he wanted to give her the down payment money. But he gave her $118,000. So in the way I think of it, the first $18,000, no problem, no gift tax consequences, as I'll call it. But dad gave her $118,000. What that means is dad has a $13.61 million gift and estate tax exemption. But by dad making a gift of $118,000 to his daughter, first $18,000, no problem. But the next $100,000, dad has to report this on a gift tax return referred to as IRS Form 709. The estate tax return is IRS Form 706 that you file when somebody dies and they have an estate that exceeds the applicable exemption. The gift tax return, when somebody makes a taxable gift, a gift in excess of the present interest annual exclusion, is IRS Form 709, United States gift tax return. So dad has to report on the gift tax return that he made the gift. And dad's going to report, yeah, I made a $118,000 gift to my daughter in 2024. This gift tax return is going to be due on April 15th of 2025. And so what dad has done, nobody owes any tax. Yes, he is required to file a gift tax return, but a check doesn't get sent in with it. What dad is reporting to the IRS is that by making his gift of $118,000 to his daughter, he just used $100,000 of whatever his estate tax exclusion amount will be when he dies. So it's $13.61 million now. If dad were to die after making a $100,000 taxable gift, then dad can now leave $13.51 million free of the estate tax. So you ought to be able to kind of get the idea there. Making a gift in excess of $18,000 to anyone in any calendar year, nobody owes any tax, but the donor, the person who made the gift, is responsible for filing a gift tax return to show that they use some of their estate tax exemption amount. I talk about estate tax exemption amount, estate tax exclusion amount, same thing. I'm just using those terms interchangeably. Okay, so that's kind of the basics of what is this $18,000 number and how does it affect people. Next, I want to go into what are some of the exceptions to what I'm calling taxable gifts. Again, I'm going to repeat myself because I know we get same questions over and over and over and over again. And sometimes I just feel like if I can repeat myself 2 or 3 times, that maybe there's people out there that are like, oh, now I get it. I didn't get it the first time he said it, but The third time he said it, it's a little redundant, but it took me that long to get it. So now we're going to talk about some of the exceptions to the taxable gifts. And again, a taxable gift is a gift in excess of $18,000 if it was made in 2024, while this gift tax exclusion amount is $18,000. Again, it doesn't mean anybody owes any tax, but it means that the gift has to be reported by the donor to the IRS to show that they're using some of their exemption. All right, but there are exceptions to the taxable gifts. So one of those is when you pay someone else's tuition and you pay it directly to the educational institution. So let's say you're, I don't know, what's a really expensive college out there, Harvard, but not many of your descendants probably are getting in Harvard. But I went to Boston University, and it was right across the river from Harvard, but it wasn't quite as hard to get into Boston University as it would have been to get into Harvard, but it's probably just as expensive. So if you have someone going to Boston University, maybe it's a child, maybe it's a grandchild, and you'd like to take advantage of some of these gift tax exemptions and exceptions that are available, yes, you could give your grandchild $18,000. In addition to that, without any kind of IRS reporting necessary, you could pay all of their tuition. So let's say they didn't get a scholarship and their tuition for the year was $60,000. You can, as long as you pay that tuition directly to the university or the educational institution, then that's an exception to the taxable gifts rules. You pay their tuition, which was $60,000. You write those checks directly to the university. And if you want to, in addition to that, you can go ahead and give the grandchild $18,000 and no reporting is necessary. So now you shifted $78,000 out of your estate and without using any of your estate tax exclusion amount. Another exception is the exception for medical expenses. So like the exception for education, where you have to pay the educational institution directly, with the medical expenses exception, you have to pay the healthcare provider directly. So if somebody has a big medical expense and you want to help them out, you can really pay an unlimited amount of their tuition and medical expenses without using any of your estate tax exclusion amount and without making any taxable gifts. Other exemptions, some people tell me, Paul, because maybe somebody might say, Paul, I'm married and, my estate is large, my spouse's estate is small, or for some reason, one spouse would like to donate assets to the other spouse. And they're like, geez, I can only give $18,000 without using my estate tax exemption. That's a mistake. So we have unlimited gifts between spouses. So if dad gives an asset that's worth $500,000 to mom, there's no gift tax reporting necessary because of the exception on gifts between spouses. And then maybe an obvious one is gifts to charity. So if you give to St. Jude Children's Research Hospital or your favorite school or church, no limit on that. I think the rationale there is the government wants to encourage people to support all of these charities and schools because they're doing the work that government would have to do if the charities didn't do it. So that's why all these tax laws favor people supporting charities. So there's an exception for gifts to charity. Okay, the next important thing I want to go over is what if you just don't want to write a check to somebody, and what if you have maybe a young child or a grandchild, you want to do some gifting, you'd like to give them a head start on life, you'd like to remove some assets from your estate that would be subject to a 40% federal estate tax if you left them in your estate until you died. What if you want to do some gifting, but you're not comfortable just writing these people a check or giving them, stock or, shares of stock or an interest in a business? Or so what do you do? Because you'd like, maybe the person you're wanting to give to is 18 years old. And if you wrote them an $18,000 check, they'd go out and spend $40,000 somehow. and the gift would do more harm than good. So you want to put that gift in a trust for them. So very, very common, where parents, grandparents, anyone for that matter, all these gifting rules where you can give $18,000. It's by no means is it required that you make these gifts to people who are related to you, but that's generally what's done. All right, so you want to gift to a trust instead of an individual. So maybe you're a 70-year-old grandfather and you'd like to move some assets, move some cash into trusts for grandchildren. You don't want to just write the grandchildren checks. And let's say your grandchildren are 18 years old. They could be 9, they could be 7, they could be 25, but you don't want to just write them a check. So maybe you're like, I'm going to set up a trust for this. My son has a son. And so what I'm going to do, because I don't want my grandson to get, grandma and I want to each give $18,000 to that grandson. So we want to give that grandchild $36,000 this year, but we don't want to just write them a check for $36,000. We want to make sure that if we're going to give it to them, we want to make sure it's used for the right reasons, used over time. Maybe they can get a benefit from it much later when they're starting a family. So grandma and grandpa are saying, I want to put it in a trust for that grandson. And so grandma and grandpa might be saying, I want to put $36,000 into a trust for my grandson. And grandma and grandpa will say, you know what? We're going to make our son the trustee of that trust for our grandson. And we're going to put some terms in that trust, like, yes, if our son as the trustee sees that our grandson needs money for his health, education, maintenance, or support, then our son as the trustee would have the discretion to make distributions to or for our grandson for those needs. So there's usually some flexibility built there. Maybe in the trust, it says, maybe the grandma and grandpa decided, let's let our son decide how that's going to be used for our grandson. And then maybe grandma and grandpa say, once our grandchild reaches the age of, pick a number, 40, then this trust really won't be necessary. And our son, as the trustee, can just terminate the trust and distribute the trust assets directly to the grandchild when the grandchild reaches the age of 40, and then they'll be on their own. All right. So there's a lot of reasons people who do gifting want to put assets in a trust instead of just dumping money or assets into the lap of a recipient of a gift. Sometimes parents or grandparents want to make gifts to minors. Sometimes parents or grandparents want to make gifts to people who are financially immature, don't know how to handle money. Sometimes people want to make gifts to a trust for a child or grandchild because they know that if they just write the check to the daughter's husband is going to go right in and take that money and go buy himself a new boat. So sometimes they want to put assets in a trust to avoid influence from a daughter-in-law or a son-in-law, and even make it kind of divorce-proof. So if the child gets married, they get to keep their trust. And maybe a child, there's some worry that because of the child or grandchild's activities, that child may get sued one day. And if that gift is in the name of the child and they get sued, successfully sued, a creditor could come out and snap that money out of their bank account. But if it's in a what I'll call a spendthrift trust for the benefit of the child, then could be protected from the child's creditors if something like that were to happen. So a lot of reasons, but the whole deal behind making gifts, keeping an eye on this gift and estate tax situation that we have. And now we're going to get into the subject matter or the title of this live stream, the $18,000 present interest annual exclusion. That those present interest words are really important, because if grandpa puts $18,000, or grandpa and grandma, let's make a little bit bigger number, put $36,000 a year into a trust for their grandchild, and the grandchild, because it's in a trust, has no access to it for some time, maybe until they're 40 is what I made up earlier, then what grandma and grandpa just did was they didn't give the grandchild a present interest in that $36,000. They gave grandchild a future interest in that $36,000, because if the grandchild is 19 years old, grandma and grandpa put $36,000 into a trust for the grandchild, but the grandchild can't access it. He can only get it when he's 40 under the terms of the trust. Then they're not giving a present interest in the gift. And that has significant consequences, because to take advantage of grandma and grandpa's $18,000 present interest annual exclusion, they do have to give the grandchild a present interest in that money. So we're going to talk about how that's done. So if they put it in a trust and it's a future interest that the grandchild has, grandma and grandpa are using their estate tax exclusion amount. They've each just used $18,000 of their estate tax exclusion amount by making a transfer to a trust that doesn't give the grandchild a present interest in that gift. So now let's move to what is a present interest when you put assets in a trust. Because normally when you put assets in a trust for somebody to get it later, that's giving them a future interest to the gift. All right. So in order for grandma and grandpa to take advantage of their $18,000 present interest annual exclusion amounts, and maybe they're doing this for many, many grandchildren. So they want to make sure that they're not using any of their estate tax exclusion amount. So to get the present interest annual exclusion for a gift to a trust, they have to give that grandchild a Crummey power. You might be thinking, boy, Crummey, that sounds like a real negative term, but it has nothing to do with Crummey. It has everything to do with a gentleman. You can't make this stuff up. A gentleman back in the 60s who fought the IRS on this, and his name just happened to be Clifford Crummey. I wish he would have had a different name, but we're stuck with the fact that Clifford Crummey fought the IRS on this back in the 1960s. And as a result of that, it has been determined that if grandparents can just write a check for $36,000 to grandson, $18,000 coming from grandma, $18,000 coming from grandpa, and that would work for using the present interest annual exclusion. But they don't like that. They want to put it in a trust for grandson. So what they have to do essentially is they can put those assets in the trust for the grandson, but they have to give that grandson for a certain period of time. Most people elect 30 days. Essentially, the paperwork goes like this. The communication goes like this. Grandson, we're putting $36,000. Your grandmother and I, grandpa's saying this, are putting $36,000 in a trust for you. Your father's the trustee. You'll get it when you're 40. If your father determines that you have needs, he'll have the discretion to give it to you for your health, education, maintenance, and support. But grandson, we're giving you 30 days to have a present interest, or we're giving you 30 days within which you can go ahead and take that money out of the trust. That's giving the grandson a present interest, even though the assets are going into the trust. So grandpa says, grandson, we're putting assets in a trust for you, and we need to comply and give you the Crummey Notice in order to take advantage of the $18,000 present interest annual exclusion that grandma and I would like to take care of. So for the next 30 days, you have the right to take this gift. And if you take it, it's yours. And if you don't take it within that 30-day period, then it's going to stay in the trust. Your father's going to be the trustee. And then you'll get what's left in the trust when you're 40. So you've got 30 days. And in 99.9% of the situations, maybe it's because there was some kind of conversation, but the grandson doesn't elect to take advantage of those Crummey rights that he has. He either lets the 30 days lapse, or maybe he signs something acknowledging that he has the Crummey rights, but he also is acknowledging that he doesn't want to exercise his Crummey rights. Because I would imagine that if the grandson takes his 36 grand and goes and buys a nice new boat or a new pickup truck, grandma and grandpa are probably going to have second thoughts about doing this in subsequent years. So anyway, that's the whole Crummey Notice. It's required when a donor is putting assets in a trust for a beneficiary or for a donee. That is generally a gift of a future interest that doesn't qualify for the $18,000 present interest annual exclusion. But if you put it in trust and give the beneficiary that Crummey Notice, then grandma and grandpa are taking advantage of the present interest annual exclusion. You see this same thing in the when some people in the life insurance business, they call these ILITs. ILIT stands for Irrevocable Life Insurance Trusts. So what happens, this used to be done much more when many more families were subject to the estate tax. The whole thought process is, hey, grandma and grandpa, when you die, I'm doing the math based on the value of your estate. Looks like there's going to be $3 million of estate tax due when you die. You could set up this irrevocable life insurance trust, make gifts to your children, and then the trustee of that trust, again, the Crummey rights are all done. Then the trustee of that trust buys insurance on the life of mom and dad. Mom and dad die, that life insurance goes to the life insurance trust, escapes estate tax, and then that creates some liquidity to be able to pay the estate tax without having to sell estate assets. So an ILIT, or an irrevocable life insurance trust, is one form of a Crummey trust. Gift to a trust is a gift of a future interest. Doesn't qualify for present interest annual exclusion. Gift to a trust combined with a Crummey Notice does qualify for the present interest annual exclusion. Okay, so that was a mouthful. And so we'll see when it comes to the chat where we are. All right. Some special considerations regarding the gifting and the $18,000 present interest annual exclusion. A lot of parents, a lot of grandparents are establishing 529 plans for their descendants. You are eligible to, they call front load 5 years of gifts into that 529 plan. So grandpa says, I want to set up a 529 plan for my grandson. Instead of doing $18,000 every year, he could front load that with 5 years. He could go ahead and contribute $90,000 to that 529 plan on behalf of the grandson. Really $180,000 if grandpa and grandma are married and they want to set up that 529 plan and front load it for the grandchild. All right. We talked earlier, just going through several considerations here. If you do make a gift in excess of $18,000, or if you make a gift of a future interest that's in excess of $0, then you are required to file an IRS Form 709, a federal gift tax return. Also, we've seen a lot of people, sometimes dad has a large asset, mom maybe not so much. So the assets that are going to be gifted are dad's, and maybe dad has children of his own and mom has children of her own, blended family. And dad would sure like to give, instead of just $18,000 to each of his children, he'd like to give $36,000 to each of his children. So gift splitting allows mom to allow dad to use her $18,000 gift tax annual exclusion. So by her signing the appropriate forms, it enables dad to gift $36,000 of assets, of his assets and his assets only, to his donees, as long as mom consents or wife, maybe in this circumstance, consents to the gift splitting. Another key point here is really key. A gift can be really a gift of anything of value. Yes, it can be cash. It can be stock. It can be bonds. It can be an interest in a business. It can be an interest in real estate. It could be a 10% interest in a piece of real estate. It could be a 2% interest in an LLC that owns real estate or 2% interest in an LLC, which is an operating business. And so when you do gift those kind of unique assets like 2% of a business or 2% of a piece of property, then you really need to get those assets appraised so that you can substantiate that, hey, you're not giving more than $18,000 to anybody in any one calendar year. But the point I want to make is the carryover basis versus the step up in basis. The reason a guy like me doesn't want to start giving some of my stock to my kids now is because I bought this stock years ago, and if I give it to my children while I'm alive, they're going to get what's called a carryover basis. If I bought shares of Apple stock for $10 a share many years ago, and now it's worth $190 a share, then when I give that share of stock to my child, the share of stock is worth $190. My basis was 10 because I gave that share of stock to my child during my lifetime. They're going to get a carryover basis. Their basis will be $10 when they go to sell it in the future, whenever they sell it, maybe immediately, maybe years from now. They'll have to pay that capital gains tax on everything that they receive in excess of the $10 a share because they got the carryover basis, which is the rule on a gift. However, if I don't give that stock to my child and I hang on to it and I pass away in 20 years when it's worth $500 a share, then my child will inherit that stock at a stepped up basis, whatever the value is on the date that I pass away. So then if they sell it, in 20 years after inheriting it, when it was worth $500 a share, they pay zero tax on that sale. So you have to be really careful about what type of assets you're gifting. Cash is a great asset to give. Most people shy away from gifting appreciated assets because they want to keep those. They may want to keep those assets in their estate, allow their survivors to inherit those assets at the stepped up basis. So I just want you to leave this live stream with the realization that if you gift an appreciated asset, the recipient's going to get a carryover basis, which is whatever your basis was. If you leave an appreciated asset to someone when you pass away, they're going to get that stepped up basis, which is a much better thing. All that appreciation just goes away untaxed. So be aware of that. Also know that, again, take advantage of it if you can financially swing it, which not many people can financially swing it, is our gift and estate tax exemption, which I talked earlier is $13.61 million. It's going to go up again in 2025, and then it's going to be cut in half in 2026 when the Tax Cuts and Jobs Act of 2017 sunsets and gets wiped off the books. There's just from now until next year, there's really wealthy people can make large gifts. So for example, a married couple, each of whom has a $13.61 million gift and estate tax exclusion right now, while that exclusion amount is elevated, they could give $18,000 to as many people as they wanted to every year. And in addition to that, if they wanted to use their exemptions, between the two of them, they could transfer $27.22 million to that next generation, all without any kind of tax being due, and with all of those gifted assets avoiding the 40% estate tax when the parents pass away. Now, if they don't make those transfers, then they're kind of stuck in 2026 and beyond when their exemption amount is $7 million. So there's just a unique opportunity for really wealthy people over the next and until January 1, 2026, to really shift some assets to the next generation and save millions of dollars of tax. All right. We talked about how you can give cash, you can give other assets. I also, on the other end of the spectrum, for you people have been waiting patiently for something that doesn't apply to the wealthy or uber wealthy. What I'm about to tell you really applies to just ordinary, John and Jane. So this has to do with how does gifting interact with, in this, $18,000 present interest annual exclusion rule, how does it interact with the gifts that people make in an attempt to qualify for long-term care Medicaid if they have to go into a nursing home so they don't have to spend all of their assets down and they qualify for Medicaid to pay for that nursing home care, which could be anywhere from $7 or $8 to $14 or $15,000 a month, depending upon where you live. So many people have kind of tried to challenge me on this one. I'm like, geez and Pete, are you serious? By saying, well, Paul, we have a couple of $100,000 in the bank. We're 75 years old. We're worried, that if we have to go into a nursing home in the future, that the state or the government would wipe us out. And so we know that there's a rule that says we can give $18,000 to as many people as we want to every year, and that doesn't count on anything, and we don't get penalized for that. Because we can because there's the rule that says we can give $18,000 to as many people as we want to. And I'm like, dude, you're talking about two completely different things. Yes, the $18,000. Yes, if you give $18,000 and not a penny more to someone in a year, you're not using any of your $13.61 million estate tax exclusion amount, which you'll never use because you don't have but a few $100,000. And so, but for potential Medicaid eligibility, if you go into a nursing home, the $18,000 present interest annual exclusion means nothing. When you go into a nursing home and you expect to qualify for Medicaid because you have maybe less than $2,000 of countable resources in your name, they're going to ask you, have you made any transfers of any assets in the last 5 years? And if you said, yep, I'm entitled to make $18,000 donations to my kids every year, I did that, but that doesn't count. Medicaid's going to say, not so fast here. If you make a transfer of any assets in the previous 5 years leading up to attempting to be eligible for Medicaid, if you're in a nursing home, you're going to be penalized and you're not going to be eligible for Medicaid. And then there's a whole kind of mathematical formula for how long you're penalized from being eligible for Medicaid. But just know that if you're sitting back in your rocking chair right now and you're 71 years old and you feel a little arthritis coming along and you're worried that you might go into a nursing home someday, I hope you don't. I hope you can stay in your home. I hope your children can help. But don't tell yourself we'll just give $18,000 to our kids every year. We'll give it to our kids and our grandkids. We'll be able to, over the next 5 years, we'll be able to really you have to qualify for Medicaid. It's kind of an all or nothing thing. You gotta get it all out of your name and make no gifts of any amount for the 5 years leading up to when you try to apply for Medicaid. So just know that those are two completely different things. All right. So what do I want to do now? I'm going to head over to the chat, see where we are. And always great to see Larry here. He's just fantastic here every time. So I did clarify 3B, the interest. And if that's what you were getting at, I wasn't talking about, bank interest. I was talking about present interest versus future interest. Hey, Amy Smith, Aaron, hello. Yep. Thank you, Larry, Aaron, why is Larry getting all the credit? So I was hoping that Paul, would get the credit for taking the time to teach us. But Larry, thanks for being on as well. Yeah, okay. Next one, Larry. Aaron, you mean Paul? All right. LD better than Fred. Yep. Call Joe. Okay. Yep. Joe, Paul, call me whatever you want. Elementary private school costs a couple of pennies as well. We adopted. She needed the extra attention. Yeah. Yeah. So same rule applies. Daughter, foster daughter, doesn't have anything to do with the person having to be related to you. So as long as you pay the school directly, that's the key. Let's see. Great, Aaron. Aaron, I think you can set up and pay the private school. Yep. Can do that too. Yep. And you can front load it if you want to. So there is that. What I didn't mention was that you now have the opportunity. I think the number is $35,000, where if the 529 plan isn't used for education, you can turn $35,000 of it into a Roth IRA for the beneficiary, which is really kind of phenomenal. And it'll grow for many, many, many years, and none of that will ever be subject to income tax. So I'm glad you made me think of that. Thank you. Does a trust giving a beneficiary the option of living in the trust property rent-free? Is this considered a gift? If it is, Is it a gift of a future interest? How is it valued? I'm going to pass on that one. There's a lot there. So you're not giving them the property, you're giving them the right to live in the property, but the property perhaps belongs to someone else. So a lot there. Hate to say it because I like to go fast. I'm going to pass on that. Would the daughter receive the money over you have to claim it now? So that's, again, that common misconception. Some people think that if you make a gift to someone in excess of $18,000, somebody owes the IRS some money, and it's just not the case. I use the example: Dad gave $118,000 to his daughter. Nobody owes any tax. Just Dad has to report that he used $100,000 of his 13.6 million exclusion amount. Johnny, is the Crummey Notice? Yeah, it's a yearly process. So every time you make a transfer or a gift to that future interest trust, it's kind of a pain, and I don't like it because it just requires a bunch of paperwork every year, and lawyers have to be involved, and people forget to do it, and then is the IRS going to check things, and then they're going to penalize you because it's a mess, and I don't like it. But yeah, it's got to be done for every gift into a trust, not just the initial time when the trust is created and the first transfer is made to that trust. Every year it's necessary. That's a great question. So that's probably one of the best questions I've seen so far. A bunch of good questions. Does the exempt gift count towards the lifetime gift amount if given to the same person for additional large gift amount? Ken, I'm not really sure what you're asking. Any gift in excess of $18,000, whether that gift is to one person or it's spread out among 10 people, if there's any gift in a calendar year that is made to a person that exceeds $18,000, the donor starts. So if he gave $28,000 to one person, $18,000 to another person, and $38,000 to another person, and my quick math, the guy used $30,000 of his estate tax exclusion amount because he gave one person more than $10,000 over the 18 and another person $20,000 over the 18. All right. Any planned changes to the gift tax like there is for the estate tax in 2026? No, we'll still have that exclusion amount. I don't envision that changing. My brother claims our mother gave him her jewelry worth over $18,000 while he was her power of attorney prior to her death. What if they never filed a gift tax form? Good question. It appears that there is no financial penalty for failing to file a federal gift tax return. I hate to say that because people need to comply with the rules, but the penalty is similar to the penalty for failing to file an income tax return. You owe a percentage of the tax that would be due, but when you're required to file a gift tax return, there is no tax due. So if the penalty is a percentage of the tax that would have been due and there's no tax due, so a lot of late gift tax returns are filed with really no penalty. Okay, so Aaron, so give cash while alive, give stocks after. Yep, that's in order to take advantage of the step up in basis on the appreciated stocks at death. Love the Crummey education. Thank you. I'm dollar cost debt. Good. Roth IRA investment, the best to pass. So yeah, Roth IRA is phenomenal. Yep, comes out income tax free to you if you take it, to your beneficiaries if they take it. So can a skilled nursing facility take this away? Well, generally speaking, it's not that they take it, but because you own it, you'll be ineligible for Medicaid. So if somebody has a $600,000 IRA or Roth IRA, since we're talking about Roth, it's not like the government is going to come in and grab that account and take it. It's just if you go into a nursing home, the government is going to say, Medicaid is not going to pay for your $10,000 a month nursing home bill. You're just not eligible. If you want to stay in this nursing home, you have to be a private pay patient until you get your countable resources down to less than $2,000. Okay, thanks, Aaron, for the smile, the emoji. I like the winking emoji. I always like those emojis. Your mom, there's also a rule from Human Services that you can only have $5,000 for life insurance, or you have to change some. So maybe that's a Medicaid rule that you're referring to there. No will, less than $18,000 gift given before death. Was that a legal gift given? Yeah, it's legal to give any amount to anybody during your lifetime. But if it's under $18,000, you don't have to do any reporting. And so if it's over $18,000, the gift is always going to be legal and nobody's going to owe any income tax on it, but you're just supposed to report it on a gift tax return. Okay, good one there. I was looking forward to presenting that. We've got some more coming up here, one on trust versus individual tax rates. It's a big one. People always get confused about that. And even a more confusing subject the next time, which is going to be, what happens to an IRA, particularly a traditional IRA after death? Lots of crazy rules there. Look forward to sharing all that with you in a simple format. What is a good write-up program to fill out a Form 709 for dummies? Maybe you start with just looking at the stuff on the IRS website, which is the form and the instructions. And then I don't know if you're referring to maybe a kind of a paid service that does all the mathematical calculations for you and all that, but there's some out there. If I loan $40,000, can I forgive interest? Good question, Doug. Okay, so let's say you do actually make a loan of $40,000 to your son. So a loan is not a gift unless it's one of these kind of loans that's really not a loan. But let's say it is a loan. You loan $40,000 to your son, and he's to pay you back. Maybe he does pay you back, but as like you're saying, you forgive the interest. So the way the IRS looks at that is they would impute an interest rate, and I'm guessing the interest that you are foregoing on a $40,000 loan. It might be, a 6% interest rate per year that you are foregoing by not charging interest or by forgiving interest. And so it's a $40,000 loan and you're foregoing $2,400 of interest. All good, because that's under the $18,000 a year that you can do anyway. So anyway, we have to impute that interest, see how much, because the fact that you're forgiving the interest is really a gift. So those are the things we have to look at. All right. When do gifts before death claw back to the estate? And so good question, Chelsea, is oftentimes there are deathbed transfers being made. And so that's just what they're called. Dad is dying and he has $1 million in his checking account and he's stroking $18,000 checks to as many people as he wants to benefit. Those checks, hopefully they get deposited before dad dies. And so as long as the gift is completed prior to death, it's out of the estate. Now, there are some rules. One in particular is if dad has a $2 million life insurance policy on his life, and he knows, and he's the owner of that policy, and he's about to die. And if he's the owner of that policy, that $2 million will be part of his estate for estate tax purposes. If he transfers ownership of that life insurance policy, there is the 3-year rule there where the life insurance proceeds really aren't out of dad's estate until 3 years passes after the transfer of ownership. But there is no clawback on gifts of cash. All right. Y'all have a great evening. Y'all take care. Thanks so much for participating. Make sure you like, subscribe, all that good stuff, and keep tuning in. Check my channel for the schedule. See you next time.